Good morning, guys. Good afternoon, good evening, good night, depending on where you are and what time you're getting to watch this video. My name is Mela Claude Ake. I am a lawyer versed in Nigerian law. My areas of practice span corporate law, sport law, intellectual property law, real estate law, aka land law, alternative dispute resolution, electricity law, startup, tech, and a few others, including energy, oil and gas, and so on and so forth. I'm also a certified venture capital analyst, as well as an accredited mediator with the Institute of Chartered Mediators and Conciliators. Today's video falls under the category of human rights. Yes, I am also very interested in human rights and public policy, because it doesn't matter what else you do, whether you are talking about corporate law or sport law or any other endeavor, human rights are so fundamental, foundational, and thus important to our overall existence. Today's topic is on the rights of an accused person. What are the rights of an accused person? Does an accused person actually have any rights to speak of? Right? Well, from my understanding of the law, flowing from the Nigerian Constitution, the Administration of Criminal Justice Act, which interestingly has also been domesticated by almost all the 36 states in Nigeria, and the fact that Nigeria is a signatory to both the African Charter on Human Rights and the United Nations Charter on Human Rights. The answer is that an accused person does have rights, and these rights have to be upheld and can be enforced. I hope that this is information that you may not have to use, because if you have to use this information, it means that you have been accused of something, you are the subject of an investigation, or you may have been arrested. But it may not be you, it may be somebody close to you. But in as much as I wish that, I know that this information could come in handy. I'm going to go ahead and talk about it. In no particular order, the first right I'm going to talk about is the right to fair hearing. As the name implies, an accused person has a right to be given audience in a court of law. That's what it means. Basically, just because you've been accused of something does not end the matter. It has to be taken to a court, right, where you'll be given the right to a fair hearing. Another right that an accused person has is the right to a public trial. While you have the right to a fair hearing, it's important that the trial be in a public place or in a public setting, as opposed to a secret trial. Secret trials are usually one of the hallmarks of oppressive regimes, autocratic regimes, anti-democratic regimes, as we have experienced in some of our military regimes in the past here in Nigeria. The benefit of having a public trial is that everything is in the open. The public can actually access the venue of the trial. The media can access the venue of the trial and witness the entire process from the beginning to the end. So the accused will not be ambushed. That is the right to a public trial. Another right that the accused has is the right to trial within a reasonable time. If you go around many police stations and even prisons, you'll find several individuals who, unfortunately, when you ask what they're doing here, first of all, if you ask how long they've been there, they've actually been there for years. And when you ask why, you will find that they are termed as people who are awaiting trial, some for 2 years, 5 years, and so on and so forth. It's a very ridiculous state of affairs. Nobody should be made to await trial for such a long time. The right to trial within a reasonable time is the right of an accused person which is affirmed by the laws and by the courts. Moving on to the next right of an accused person, you have the right to a presumption of innocence. You're innocent until proven guilty, as the maxim goes. An accused person is not to be treated as though he or she has been found guilty ab initio, because there still has to be a process which is going to determine his guilt or his innocence at the end of the day. And the courts are the ones who the law has given that authority to determine that. Another right of an accused person is the right to adequate time and facilities to prepare for defense. For instance, you can't arrest somebody today for an offense and tell them, "Defend yourself right now." After being informed of what the offense is, they have to have enough time and facilities to be able to prepare a robust defense. Another right of an accused person is the right to be informed of the offense they are accused of. So somebody has been invited by the police to the police station, or invited by the EFCC or the DSS, or has been arrested by any of the investigative bodies. Well, that person who has been accused has a right to be informed as to what offense they are being accused of. They have a right to be informed by those who are effecting the arrest or the invitation. Another right of an accused person is the right to defend himself, either by himself or by counsel, that is, by having a legal practitioner stand as his attorney. An accused person also has a right to examine or cross-examine the witnesses presented by the prosecution, as well as the evidence presented by the prosecution. Another right of an accused person is the right to an interpreter. So if an accused person doesn't understand the language that is being spoken by the investigative agencies or by the court, he has a right to have an interpreter to be provided for free, who will help him or her understand what is being said, so that the accused has a full understanding of what exactly is going on. Another right of an accused person is the right to obtain copies of the judgment. At the end of a proceedings, when a verdict has been given, an accused person has the right to obtain copies of that judgment. Usually, if he has been found guilty, having the copies of the judgment helps him prepare adequately for an appeal if he chooses to appeal, or if he has been found innocent, it helps him to keep that as evidence of his innocence. An accused person also has a right to not be tried on retroactive legislation. Retroactive legislation. What is retroactive legislation? Well, retroactive legislation basically is trying somebody for an offense that was not codified in law as an offense as at the time the event occurred. Let me break that down. You say Mr. A slapped Mr. B on the 3rd of October, but on the 3rd of October there was no law in force that said that slapping somebody was an offense. There was no law within that jurisdiction, whether nationally or at the state level. And then on some date after the fact, a law was passed criminalizing slapping somebody. And then Mr. A is arrested and is being tried on that law. Well, that is wrong. That is unconstitutional and that is unlawful. You are backdating the law because the law was not in force as at the date of the event. So it couldn't have been a crime when he did what he did, because there was no law that labeled it a crime. Because a crime is a crime or a criminal offense because there is a written law that states that such an act is criminal. So if somebody did something on a date where there was no law that criminalized that act, then that act is not a crime. And therefore, even if much later a legislation is passed that criminalizes that act, he or she cannot be tried on the basis of that legislation that came into effect much after the fact. Another right of an accused person is the right against double jeopardy. So in a situation where an accused person has been arrested for an event that occurred at a particular date and time, went through the court process and was found innocent and acquitted by the courts, that accused person who is now acquitted cannot be retried for that same offense with that same specific set of facts. And that includes not just the act itself, but the date which the act was committed, the person against whom it was committed, and so on and so forth. If there is a similar offense with a separate set of facts, including the date, time, and all that, that does not count as double jeopardy. Let me help you with that. If Mr. A slapped Mr. B on the 3rd of October, and let's say it was a crime, a criminal offense, and he was arrested and taken to court, and the court found him not guilty, acquitted him, a prosecution cannot bring that exact same matter that Mr. A slapped Mr. B on the 3rd of October. Now, if the prosecution is saying Mr. A slapped Mr. B on some other date, right? Now, that is a separate set of facts. There is now some variation. So that's a different thing entirely. Moving on, an accused has a right not to be tried for an offense already pardoned. A pardon is where the state says, you have been forgiven for your offenses, you will not pay for your crime, go and sin no more. If an accused person has received a pardon, he should not be tried for that offense for which the state has pardoned him already. Another right of an accused person is the right to silence. This includes the right to silence at the stage of being in police custody, where he has a right to keep quiet and not incriminate himself until he has his lawyer present, especially if he feels that he lacks the competence to adequately respond to the questions that are being asked of him by the investigative agencies. That is the right to silence. Another right of an accused person is the right to be tried only for an offense known to law. So, like I said before, the only thing that makes an offense criminal is if there is a law that has criminalized that act. So if at the date of commission or at the time of commission there was no law in force known within that jurisdiction that criminalized such an act, then you cannot try an individual, because on what basis are you trying him? It is not a crime because there's no law that has criminalized what he or she has done. Another right is the right to not be tortured. This is a huge deal in not just Nigeria but around the world. Even in some very democratic countries, torture is still an issue because some individuals in investigative agencies and law enforcement generally feel that torture is effective and cheap to quickly resolve their investigation. But we have seen time and again that many times, which is the same thing as time and again, individuals in the law enforcement agencies, some of them, not all of them, have abused this tool. It is not even supposed to be considered a tool because a lot of the time the confessions that are gotten under duress and are not always the truth. And unfortunately, we find individuals admitting or confessing to crimes that they didn't actually commit because of the violence that was unleashed upon them. So, an accused person has a right to not be tortured. He also has a right to not be, handled. These few points of mine, I hope that I've been able to throw a little light on this very important topic. Remember that your rights are yours to enforce. If you feel that you or somebody that you know has had their rights violated or infringed upon in any way, it may not have to do with rights of an accused person. It may just be any other fundamental human right. Do well to reach out to a legal practitioner who will advise you and guide you on what should be done to enforce your rights. There is a remedy under the law for those whose rights have been infringed upon. You can actually file a suit against any organization, any individual who has abused your rights in any way, shape, or form. I am Barrister Mela Claude Ake, thanking you for your time. Do well to like the video, subscribe to the channel, and click on the notification bell so that you receive notifications when other videos are uploaded. Thank you so much. I look forward to seeing you on the next video. Enjoy the rest of your day.